Hello, good morning, everyone. Thank you very much for having me. My name is Johnathan, like you heard, and I'm an employment lawyer here in Mississauga. And I'm happy to speak to you today about termination. So the first thing I'm going to do is to remove my self-view. We're all becoming experts on lighting and how to look good on screens now. So I don't want to have to keep looking at myself here. But I'm happy that everyone here can see me. So like was mentioned before, and thank you, Angelica, for that introduction. If you do have any questions, please use the question and answer section, and I can keep track of the answers and type answers in or answer them live. And I see there's already 2 questions here, so we have some early birds, so I'm happy to answer those questions. And I'll get to them either throughout the presentation and I have left time at the end of the presentation for answering more questions. So I'm happy to do so. So today, of course, yes, we have a legal disclaimer. You can't talk to a lawyer without having a legal disclaimer, just so that everyone knows this isn't legal advice that I'm providing today. It's information. But if you do have any specific questions, I'm happy to talk to you after the presentation and talk about your specific matter. So today we're talking about termination. Terminations specifically in the province of Ontario. And there's 4 areas that I want to talk about the different types of terminations. Okay, so we have for cause or just cause terminations, without cause terminations, which are the majority of the terminations that take place. We're also going to talk about constructive dismissal and frustration of contract. And if you haven't heard what that is, we'll get to that because I think a lot of employers should know what that is before it happens to them in their workplace. So before we get into all of the aspects of termination, I want to talk about the employer obligations, okay? Because this is really the baseline for what is acceptable, not acceptable, what is expected in the employer-employee relationship. So really, I broke it down into 4 parts. So of course, we've all heard of the Employment Standards Act. The employer is legally obligated to provide all of those minimum standards to employees. It's not just notice of termination. Any employers here know there are lots of standards. There's breaks, there's time between shifts, of course, minimum wage. And by the way, minimum wage is increasing on October 1st. Vacation pay, there's leaves of absence, holiday pay. So of course, it's the employer's obligation to comply with all laws, but especially the Employment Standards Act. And there's unwritten obligations. So it's the employer's obligation if they have indicated to a person that they'll hire them to do certain tasks, that the employee will work, and the employer will pay them for that work. Okay, and I know it sounds that sounds basic, but really these are the basic tenets of employment law, and they'll come into play when we talk about types of termination and constructive dismissal. The next one, fair and equal treatment and treating employees in good faith. And that's a standard obligation, really, that also implies that the employer is obligated to provide a safe workplace for all their employees. And of course, the Occupational Health and Safety Act tells employers that they are to provide, all reasonable. The wording just escapes me. They're to provide all reasonable, take all reasonable steps to provide a safe and healthy workplace. And so that falls under that category. And of course, that as I just mentioned, a safe environment. And so treating employees in good faith, what it also means is, treating them honestly and not misleading them intentionally or unintentionally. So those are kind of the employer obligations, and you'll hear me touch upon those as we talk about the different types of termination. Okay, so first I want to talk about for cause termination, because this one, it's not the most common type of termination, but where employers need it, it is there for them. So really, if we go right to the Employment Standards Act, and what that says is, you can terminate an employee for essentially 3 reasons, and they're very good reasons. So the Employment Standards Act specifically says you can terminate an employee for cause for willful misconduct, disobedience, willful neglect of duty that is not trivial and not condoned by the employer. That's specifically out of the Employment Standards Act regulations. Okay, so if you have any employees and they are found guilty of one of those three things, or some of them, or all of them, the employer has a right to end the employment relationship, and provide the employee with no notice and no pay, and consider the employment relationship completely severed as of the time that the employer finds the employee guilty of that. So what I want to point out here, we see the word misconduct. It's not just regular misconduct. The Employment Standards Act says it's willful misconduct, and it's not just regular old neglect of duty. That's not trivial, not condoned by the employer. It's willful neglect of duty. So what that implies to the employer is, of course, it's going to be serious misconduct, but it has to be, the employer has to have evidence that the reasons for terminating that employee, that they were already known to the employee, and that employee knew or ought to have known that breaking a standard or breaching a certain agreement that they had, or not doing something that the employer asked them to do, or not following their specific job duties, that they knew that at the time. Okay, so it's not just regular misconduct, although misconduct is inappropriate in any workplace. It has to be willful misconduct. In order to terminate an employee for cause, it has to be willful misconduct or willful neglect of duty. So progressive discipline, if you've heard of that before, progressive discipline is necessary. Progressive discipline is essentially when you take an employee through a verbal warning, a written warning, and then different suspensions, maybe a paid suspension, unpaid suspension, and possibly more than one of those, of each of those, ultimately leading to a full termination of employment. And so progressive, you can see it gets progressively more serious for the employee. And really the intention there is that the employee understands that their employment is at risk. And if they continue doing what they're doing or what they were told not to do, there will be consequences. And that's the hallmark of any valid for cause termination, that the employee knew that what they were doing was wrong and inappropriate, and it constituted misconduct, and they were warned of that probably several times, and ultimately they were terminated without being paid and given any notice and any other entitlements. So my advice to employers is always document, document, document. Verbal warnings are great. If they aren't recorded down somewhere, and I mean even just written down, or an email to a supervisor, or an email to yourself, or a memo to the employee file, it's a lot harder to show, if the employer needs to, that they took part in this progressive discipline. So it's important to document all forms of discipline within the employment relationship. And ultimately, the goal is that the employee improves their behavior. And if they don't, they will face further consequences. Right, so I'm in between my slides here. I will look at the questions here at the chat, and I see there's some questions here in the chat. What I would say, yes, please put your questions in the question and answer section, and I will answer them either at the end of the session or throughout. And I see there's 4 questions here. And I see there's a new question that talks about performance reviews. There's a new question that talks about termination without cause. So I'll answer those questions as I'm speaking about termination without cause, or by the end of the presentation. So we talked about for cause termination. That's where the employer has a genuine reason. Like I said, there's those 3 reasons that an employer can terminate an employee. It would be willful misconduct, disobedience, willful neglect of duty that's not trivial, not condoned by the employer. if there are any other reasons for terminating an employee that aren't those three reasons, and of course aren't discriminatory in nature, that type of termination is a without cause termination. And this is probably the, by far the most popular and the most, probably the most appropriate way to terminate an employee in Ontario. And, the Employment Standards Act is very clear that every employee is entitled to reasonable notice and reasonable notice of termination. And of course, judges in Ontario are also very clear that every employee is entitled to reasonable notice of termination here in Ontario. So, of course, a without cause termination, like I said, is any reason that isn't one of those just cause reasons and isn't a discriminatory reason. But of course, it is not. It's not mandatory for the employer to tell an employee and to give them a reason for why their termination has occurred. And so frequently, I will ask employers if it's necessary that they provide a reason. There might be some important cases, important instances where it is appropriate to provide the employee a reason. I mean, if the operation is completely closing down, that might be one good reason to provide a situation that you would want to provide a reason for termination. But for the most part, I normally advise employers they're not required to give a reason for termination. Okay, so there could be many different reasons that an employee could be terminated. Of course, they're not going to be discriminatory, and they won't be one of those for cause reasons. So when we talk about a without cause termination, right, the hallmark of a without cause termination is that employees are entitled to reasonable notice of termination. That can be either through working notice, or it can be pay in lieu of that notice of termination. What is reasonable? Okay, well, reasonable really is the hallmark. So how do we know what is reasonable? Well, there's two parts that we would look at. The first part, immediately, if any employer here is considering terminating an employee, you have to look to the contract. You have to see exactly what the contract said, and whatever is guaranteed in that contract, that must be provided to that employee. Okay. Typically, employment contracts will say that the employee is entitled to the minimum amounts of reasonable notice within under the Employment Standards Act, and there may be a contract that says the employee gets more than those minimums in the Employment Standards Act. There might be instances, which is common for a lot of employers, that there is no written employment contract, or it's a very old employment contract. Maybe nobody can find it. We don't know what it said. If it was written maybe 20 or 30 years ago, which has happened. And in those instances, we would proceed, to deal with that termination as if there is no contract. So what do we do if there is no contract, or if it's a very old contract? Right. Well, we'll talk about these special situations, but here I'm going to talk about the minimum amounts of termination pay or termination notice that have to be given. And I will go back to my previous slide that talks about layoffs and other matters, and I know I've received some questions about that already. So in terms of the minimum amounts of termination pay that have to be given to employees, the Employment Standards Act says essentially the employee gets 1 week of pay for every completed year of service that they have. And so, and I've detailed that when I say it's around 1 week. So as soon as an employee completes 3 months of service, they're entitled to 1 week of notice of termination under the Employment Standards Act. As soon as they pass 1 year of service, they're entitled to 2 weeks of notice of termination as a bare bones minimum under the Employment Standards Act. After they pass 3 years, then it's 3 weeks of service, up to a maximum under the Employment Standards Act of 8 weeks. And there's an additional payment for Ontario employees, and that's called severance pay, and it's very specifically defined under the Employment Standards Act. But not every employee gets the special severance pay under the Employment Standards Act. Now, for the employees who do, right, they would receive 1 week of pay for every year of service that they've worked, including partial years, to a maximum of 26 weeks. But the employees that are entitled to severance pay in Ontario, they have to have completed 5 years of service, and the employer has to have a payroll of over $2.5 million in a year. And there are some other situations if there's a complete discontinuance of the employer's operation, depending on how many employees are affected. Certain employees might be entitled to a special employment standards severance pay at that time. But generally, for the most part, if an employee has not completed 5 years of service, they are not entitled to that special severance pay. But really, when we are talking about when we're terminating an employee, and if there is no contract or if there's a very old contract, well, what do? We have to look at the common law standards for minimum termination pay. And by common law, I mean judge-made law in Ontario. So when a judge hears a case, they make a decision in favor of the employer or the employee, and that forms part of the common law. So there is this benchmark of approximately 1 month of pay or notice for every year of service that the employee has completed, right? And so, and that's usually to a maximum of 24 months. However, there are some instances where certain employees, in rare circumstances, but they do occur, where some employees are entitled to more than that maximum of 24 months. But generally, it's approximately 1 month of pay for every year of service. However, if a judge is asked to evaluate what is proper reasonable notice for an employee in Ontario, they're going to look at a variety of factors. The most important of those factors would be the employee's age at the time of termination, their tenure, how long they've worked for the employer, the type of job that they have, and the availability of similar jobs within a reasonable area around where the employee lives. And there are actually a variety of other factors, but those are the most important factors. So generally, the older an employee is, the longer they've worked, and the more senior position that they have, the more notice of termination they are entitled to. So for example, if there's an employee who has worked for 5 years and they happen to be 65 years old, well, a judge, and let's say they're in a mid-manager level position, a judge may say they're entitled to 7 to 10 months of reasonable notice, because judges have repeated in cases in Ontario that older employees are entitled to a greater amount of notice of termination in Ontario. And the same applies for longer tenured employees. The same applies for more senior employees. Every case is different, and so it's important to speak with HR or an employment lawyer to ensure that you're following at least the minimum standards under the Employment Standards Act, but also the other standards as in the common law. So I want to talk about some special situations with regards to without cause terminations. So we talked about there could be a variety of reasons that may or may not be disclosed to the employee. But there are some other situations where an employer may have terminated an employee, but not actually known that they've done it. So one of the ways there is layoffs, and I know layoffs is a hot topic right now for a lot of employers with all the changes that have been coming through in Ontario. So before I talk about layoffs, I'll say we currently, as of right now in September 2020, we're in a very special period where the provincial government has amended the Employment Standards Act to put a pause on any layoffs that have occurred since the beginning of the pandemic. And so to be brief, the provincial government has amended the Employment Standards Act to say any employee who has experienced a reduction in hours, they would technically be on a special leave of absence. And it is not considered a layoff if they have a reduction of hours. and it is not considered a constructive dismissal and is not considered a termination of their employment if the employer has not provided them the same amount of hours as under their contract. So it's a very fluid situation. If you have more questions about these specific changes with regards to the special leave of absence, give me a call or send me an email, and I'm happy to speak in more detail about your operation there. But when we're dealing with layoffs, generally speaking, when we're not in this special period, where there's a layoff that lasts for more than 13 weeks consecutively, or more than 13 weeks in a 20-week period, or more than 35 weeks in a 52-week period, where the employer typically where they have continued benefits during that time, a layoff can bring about a termination automatically. Okay, so there is a mechanism under the Employment Standards Act that says, beware employers, if you've laid off an employee for too long, it could automatically turn into a termination. And if you'll let me throw a wrench into all of that, I mentioned the common law, what judges have to say about layoffs. If you ask a judge in Ontario, what the law says about layoffs, they'll tell you that there is no automatic right for an employer to put an employee on layoff unless it's specifically written in an employment contract. And this is despite the fact that the layoffs are dealt with very clearly within the Employment Standards Act. So having written employment contracts are key for any employer if they're considering laying off an employee. If they don't have written contracts and they are planning to lay off an employee, it's important to speak with an employment lawyer or with an HR professional so that you can understand all of the risks and what may happen in the future. There are some employees who are not entitled to any notice of termination at the end of their employment. So first of all, these would be, there's two types that I've drawn attention to here. So number one would be a fixed term contract employee. If you have a contract with an employee, it could be written, it could be a verbal contract, and you tell that employee, I will only hire you for 1 year. At the end of that 1 year, that employee is not entitled to any notice of termination. And the law is very clear about that. If they work for those 12 months, let's say it's a 1 year contract, they work for 1 year, you've paid them for 1 year, there is no additional notice of termination that is owed to that employee. Now, if that employee who's on a fixed term contract of 1 year works 366 days, well, now they're on a new contract, a verbal contract, and a verbal contract, as I mentioned before, if there's no written contract that explains what type of termination notice that employee is to receive, that employee may and probably will be entitled to notice of termination, as I've talked about before. So if there are any employers listening here and they have employees who are on fixed term contracts and they have gone past or well past whatever that time was, I think it's important to speak with an employment lawyer so you can understand the risks and understand how you can mitigate that. And there's also an exception under the Employment Standards Act for probationary employees. So a probationary employee is not entitled to termination notice, and that is if they've worked less than 3 months, and that's made very clear in the Employment Standards Act. However, if you ask a judge in Ontario if an employee who's worked for less than 3 months, if they are entitled to notice of termination, that judge will likely say yes. And the judge will say every employee is entitled to notice of termination, and it's based on their age, their length of employment, type of employment, and how quickly they can find another job. So whenever an employer is considering terminating an employee, it's always important to get proper legal advice before the termination takes place. So I'm going to just take a look through some of these questions now, and I will answer some of them based on what we've talked about here. So I see a question from Sarah. How old is too old to disregard an old contract? That's a good question. So in my opinion, if there is a written contract and it's clear and everyone knows about it, that's a good contract. If it's not clear when a contract was written, if the employer doesn't have a copy, the employer's not sure if the employee has a copy, I would say, you may not have a valid written contract. But there can be a verbal contract. And in that case, it may be very likely that that contract has merged into a new verbal contract, and there's nothing wrong with a verbal contract. Just, if the employer is considering terminating that employee, it may be appropriate to, well, first of all, get legal advice, but that employee might be entitled to more than just the minimum termination notice. I see another contract here about an old contract. So Charmaine says, if I have an employee who's been with the company for 10 plus years, should we be updating the employment agreement? I think if there are contracts that are, even 5 years old or more than that, I would say it's important to review the contracts. In another sense, I think, now is a very appropriate time for every employer to review their contracts. And that's because there was a very important case that came out in June of this year in the middle of a pandemic, and it kind of changed the employment law sphere in a great deal. So I will speak about that in just the next slide. But to answer that question, even a contract, if it's a contract that's over 10 years old, I think for sure it should be updated. But even for contracts that are a year old, as of now, I think they should be reviewed. We have a question about probationary employees. So since we talked about them, I'll address that here. Would the probationary period be extended if the employment contract extends the probationary period to 6 months? So a probationary period, technically, it's not actually written in the Employment Standards Act of what a probationary period is. If you try to find that term in the ESA, you won't find it. So, but what the ESA does say is if an employee has worked for less than 3 months, and the minimum amount of termination notice they're entitled to is 0. So generally, it's accepted that a probationary period is 3 months. If you want a probation period to be 6 months, that's fine, because technically every employee is on probation, in my opinion. Every employee can be terminated for a cause and be given no notice of termination if they're guilty of willful misconduct, disobedience, or willful neglect of duty. And so for me, I think an employer should have a good idea in the first 3 months if they're going to keep an employee on. I see there's a question here about verbal warnings and written warnings, so I'll address that, and I'll just keep track of time. So we're doing pretty good for time. Tracy asked the question, what if you only give verbal and written warnings, stating if it happens again, they will be terminated? Mainly the abuse of alcohol and using a company vehicle. A signed policy was also signed by the employee. So the hallmark about, one of those just cause terminations like I talked about is, that the context is important. So if an employee has been warned 1 or 2 times, but it's very serious conduct, that might be a case, Tracy, where it is appropriate to completely terminate an employee if they've been given 1 or 2 verbal warnings. But like I said, it is important to coach that employee and very clearly explain to them what they're doing is wrong. And I think a signed policy is a great idea for that. And suspensions are also a really good idea. Suspension is like a termination light. A suspension is like, we are on our way to terminating you, and this is a very clear warning. And a suspension with pay and a suspension without pay. So I think before you jump to a full termination for a cause, consider suspending the employee. There's another question here from an anonymous attendee, and I'll answer it briefly. Are yearly performance reviews mandatory by law? No, absolutely not. Can an organization get in trouble for not doing management reviews? There's nothing in the Employment Standards Act that says that performance review is mandatory, so I would say no. I think it's a best practice, and my HR colleagues in this employment law sphere would probably say it's a good idea to track performance. So I'm going to go back to the presentation, and I will answer some more questions. And I see there might be some more questions in the chat, and so I'll try to get to as many as I can. And if I don't get to your questions, what I can do is I can send you an email, or you can send me an email directly, and I can provide you with some extra information if you need that. So we've talked about the minimum termination pay. We've talked about some special requirements. My goal is that employers don't end up here. And I wanted to put a picture of a courtroom. And this is what a typical courtroom in Ontario will look like. although now with social distancing, it looks a lot different. But this is generally what the court is, and you have the lawyers who are sitting on each side and the judge who presides at the top, and then we have some court clerks and registrars, and we see the witness box, and would be a jury box on one of those sides. My goal is to avoid employers from showing up here. And how do employers typically, end up in court? Excuse me. They end up there because they don't provide reasonable notice of termination to their employees, whatever reasonable may be. So I mentioned that there was that very important case, and so I want to stress again, it's important for especially for older contracts, if they've been 10 plus years, it's likely that contract, that termination clause probably needs to be reviewed. But even the most recent termination or most recent employment contract should be reviewed. And this is why. In June, Ontario's highest court basically told employers, you need to review your contracts. And that's because the highest court in Ontario said, if you have a termination clause and it contains an unenforceable for-cause termination clause, right? So you remember what for-cause was? Those willful misconduct, disobedience, willful neglect of duty. If you've worded it in a way that makes that section void, the entire termination clause is void, including the good part, including the part that talked about without cause. So this was Ontario's highest court very much confirming something that a lower court had mentioned a couple years ago, but had never made it to the Ontario Court of Appeal. So this was significant. Generally speaking, a court is usually going to side with an employee in a court case, and that's because the Supreme Court of Canada has confirmed time and time again that because there's this power imbalance between employer and employee, the court, if they need to step in, the court will usually step in to protect the employee and not the employer. So anything the employer does has to be absolutely crystal clear. If there is any ambiguity in a contract, anything, a court is going to look at it and say, I'm going to favor the employee in this case because there's ambiguity, something that's not clear. So in this case, the employer had a clause that simply said, if we want to terminate you for just cause, we will terminate you for just cause and give you nothing, essentially is what it said. What the court said in that case was, that is a different standard than that first standard I talked to you before. We have just cause, which is just really two words that courts have analyzed and made decisions on for the past many decades. And then you have the Employment Standards Act that says willful misconduct, willful neglect of duty, and disobedience. That's not trivial, not condoned by the employer. So the court said, we know what the just cause standard is. You can't give the employee anything that's different than that just cause standard. So the entire termination clause is void. So in the case, if you wanted to look it up, it's Waxdale. And if you type in 2020 ONCA 391 online, you could probably find some more summaries of that case. So I've been alerting every employer I can speak to review their employment contracts right away. Because even if you signed on a new employee in January, that termination clause might be void. It might not, but there's a chance it could be. So, and I want to avoid, of course, having employers show up here in court. And it's really not that cold as it makes it look. Normally it's pretty warm in there anyway. Let me just look at the questions here, see what we have. So I see some more detailed questions, and they're good. I'm going to get to those detailed questions near the end. So just give me about 5 or 6 more minutes, and I'm going to go through the last two parts of my presentation, and then I want to address the questions. So there's two other types of termination that I want to talk about. Constructive dismissal, which you may have heard before. Constructive dismissal, and I put this image of a construction site, because for me, when I think of constructive dismissal, I think of that it has to be, it's built, okay? And you have to take a situation and build the dismissal. You have to construct it, right? So when you put all these different factors together, it's going to form a dismissal. That's what I think of. But at law, there's really two, kind of similar definitions of what a constructive dismissal is. And really what I mean here is that if an employer has terminated without cause, terminated an employee, but they don't know it. So one definition is a substantial unilateral change to the terms of employment without reasonable notice. And the second way that you can define constructive dismissal is where the employer has shown they no longer want to be bound by the original employment agreement. Now that employment agreement might be written, but it also might be verbal. And even if it's a written contract or a verbal contract, the employer still has those obligations to every employee. They have an obligation to have a safe workplace, to pay their employee what they said they would pay, to, if they agreed on a certain schedule, to give that schedule to the employee. If they agreed on certain job duties, to give those job duties to the employee. And so if the employer has shown, though, they're not going to be bound by that original employment agreement, it could bring about a constructive dismissal, and that would lead you right into, these minimum or maximum termination requirements that I talked about before. And I will have copies of these slides, of course, for anyone who wants them, and I'll organize with Angelica to get those to you. So if for employers who have maybe changed a job slightly, changed pay, changed job duties, changed a schedule, definitely get in touch with an employment lawyer and determine whether you have terminated an employee, but you just don't know it yet. Right, and here's some of the significant changes, like I already mentioned: their pay, their hours, their duty. Bullying and workplace harassment has been recognized as a way that an employer has constructively dismissed an employee. And of course, as any employer here probably knows, the employer has an obligation to protect workers from any in the workplace, and take all reasonable precautions to protect workers. And one of those is workplace harassment. So if there is workplace harassment in a workplace and it's not investigated and it continues, that could very easily lead to a full termination without cause, and the employee is entitled to their minimum amounts and possibly the 1 month for every year that they've worked amounts as well. And I made a note here about insignificant changes, because I talked about one of the definitions was, well, a significant unilateral change without reasonable notice. If it's an insignificant change to employment, then that would not be considered a constructive dismissal. Now, what is significant and what is insignificant, it would only be done on a case-by-case basis, so the context very much matters. But one of my examples is, if an employer wants to change the way that vacation is taken or that vacation is scheduled in a workplace. I'm not talking about changing the days of vacation, changing how much pay they're getting, but really it's just, this is the new method for how we are scheduling or selecting vacation. Or let's say an employer, if they wanted to force employees to take certain vacation at certain days. The employer's not saying they're not getting their vacation. Everyone will get their vacation, but it's, we're going to have a plant shutdown the beginning of July, plant shutdown the end of December. That is, in my opinion, is not an insignificant change to employment, because the employee is still receiving all of their vacation that they're entitled to receive in a contract or under the law. So that wouldn't be significant. But I think there would probably be a fine line between, for employers versus employees, for what is significant, what is insignificant. So definitely speak with HR, speak with an employment lawyer to talk about what is significant and what is not. The last part that I want to talk about before I get to the questions is frustration of contract. So this is another way where an employment contract could be terminated, but the employer and the employee don't actually know that it happened. So the definition in law from a case from last year, I think they summarized it very well, and actually this might answer some of the questions that were prepared, that were given in the Q's and A's there. Where an employee cannot complete the basic job obligations the basic obligations of their job duties in the foreseeable future, the contract is frustrated and the employment relationship is ended. So that's a very much I already see more questions here and more chats that are being sent here. So it gets a little more complicated. This isn't like your run-of-the-mill without cause termination. This is where, typically it involves accommodation of employees and human rights. Sometimes it involves certain licensing of employees. If an employee, this is my textbook example of frustration of contract, if you hire an employee and they must have a driver's license, and their job is to drive a truck for 8 hours a day, and they lose their license, that would be a frustration of contract, right? The employee cannot complete their basic job obligations in the foreseeable future. Contract is frustrated. Now, if it's a temporary suspension, maybe the contract wouldn't be frustrated. If they're a doctor and their medical license has been revoked, that would clearly be a frustration of contract. But how it relates with accommodation and disability and human rights, it is, what I'll say, it's not straightforward, and it really involves an HR professional, an employment lawyer, to say, okay, we have now reached the point where the contract is over, or maybe we haven't. An employer is obligated to accommodate their employees, to reasonably accommodate them to the point of undue hardship. But at what point can the employee return to work? At what point can the employee not return to work? Is it foreseeable? Is it not? Can they perform some of their basic job obligations, but not all of them? These are all very important questions when we're dealing with frustration of contracts. So my advice is to always proceed with caution. If you're faced with a situation where you have an employee who, through no fault of their own, can't return to work, speak with an employment lawyer. So before I get to the questions, there's these things, little tidbits that I wanted to provide for employers. So I'm just going to leave them on here. I'm not going to go into great detail about them. But I mentioned before, an employer can force an employee to take a week of vacation. It is completely valid, completely permitted, and I think that's something employers should know. If an employer has questions about a request of the employee, they can ask for reasonable evidence. And there's nothing wrong with that. And there are lots of different areas in the law where that can be done. And like I mentioned before, they can terminate without giving a reason. And at the same time, they can also impose new contracts, but I very much would caution you to speak with an employment lawyer. And, on the other side, what employers cannot do, they cannot unilaterally cut hours. They cannot ignore harassment. Don't ignore an obvious disability of an employee. And don't forget about your policy manual. They do have to be reviewed at least once a year. And really, there should be evidence that the employer has reviewed their policy manual at least once a year. So on that note, we're doing pretty good for time. I know we started a little late, about 5 minutes late. So I want to take some time and answer these questions. So I'm going to go to the Q&A first. And so if there is some more questions in the chat, or if there's a question that I don't get to, I'm happy to put up my my email and phone number here. I'm happy to chat with any employer who wants to talk. So let's start from the top, because I think that's fair. So I want to deal with the questions that relate to what we're talking about here in termination. And I know there probably might be some questions about COVID and COVID-related issues. So I'm happy to speak about that after the presentation. So I want to deal with the questions related to termination. Can I discuss unforeseen circumstances, termination of employment? Someone understands from HR that they can terminate an employee under unforeseen circumstances, as most of our business is currently closed with no opportunity to reopen and not pay termination or severance pay at all. So number one, like I said, an employer doesn't have to give reasons for termination. However, I would say almost every employee, especially if someone has worked for 28 years, every employee is entitled to notice of termination. Some employees are entitled to Employment Standards Act severance pay, but every employee is entitled to notice of termination. How much termination pay or notice, that depends on the employee. This is a question about temporary layoffs. This is a good question, and we talked about it. So I believe I addressed that, and so just to recap that. A short layoff in Ontario is 13 weeks within a 13 weeks within a 20-week period. A long layoff is 35 weeks within a 52-week period, only where the employer has satisfied certain conditions, and the most popular one is continuation of benefits. Benefits have to be continued. However, like I mentioned, we're in a very special period right now where layoffs have currently been suspended. And so I would encourage you to speak with an employment lawyer to understand fully what has happened with layoffs right now. So this is a question. We have someone, can an employer terminate one person and bring in a new person? The answer is yes. However, an employer has to be sure not to discriminate against any employee. If they have a 65-year-old person and they terminate them just because they're 65, so they can bring in someone who's 25 years old, that may result in discrimination, and it could result in additional damages having to be paid by the employer to the employee. Some further questions down here. So this is about, Diane talks about there's a one employer rule in a long-term care facility. That's a new rule that took place in Ontario during the pandemic. 40% of their staff took a leave of absence during the pandemic so they could work full-time elsewhere. Is this leave of absence to be considered the same as a layoff? That's a very good question. What I would say, I think for that question, I would definitely want to get into more of the details about what those employees said, what has actually happened over that time. But I think considering all the circumstances, I would say a judge, might reasonably say that, it is a leave of absence and it should be recognized. But I could also see another judge saying, listen, an employer doesn't have to accommodate an employee for having a second job. So it's definitely, I think there's arguments on both sides of that question. Would it be considered a layoff? Maybe, maybe not. So I think I would want some more information about that. Diane, I'm happy to speak with you in more detail if you'd like. Anka asked a question, if you update the contract, you have to give something in return so that they sign. Yes. And so what that is Anka, you've touched upon a really important point, which is if there are any changes to an employment contract, and typically, one of the most popular changes are wage increases or salary increases. And typically you don't need a signing bonus, like you've mentioned here, Anka, for a wage or salary increase. But if there are any other changes, typically an employer has to provide a signing bonus to that employee to enter into that updated contract. So that is a very good point. And if you'd like more information about that, I'm always happy to speak about that. Lisa asked, can you fire an employee for non-productive work after 3 years? The answer is yes. As long as you have warned the employee, as long as you have undertaken progressive discipline, you've given them a verbal warning, written warning, maybe more than just one, and you have suspended them with pay and suspended them without pay. If you show me 4 or 5 or 6 letters confirming all of that, I would say, we can talk about a for-cause termination, or really a termination where the employee is not entitled to any amounts. And I'm happy to speak about that in more detail. Mark asked a question, if an employer gives a 6-year employee 6 weeks written notice of termination, and they find another job and leave before the 6 weeks is up, do you have to provide them with the remaining weeks of pay? That's a good question. That is specifically dealt with within the Employment Standards Act. So Mark, if you catch me, or if you want to contact me offline, I can direct you to that. But the short answer is no, but I would want to speak to you a little bit more, because the employees also have an obligation during that time to the employer. But generally, if the employee resigns, they are not entitled to any additional amounts from the employer, but it's always dealt with on a case-by-case basis. Let's see. There's questions about invalidation of contract. I see there's a very detailed question here about ESA minimums. Let's see. Someone asked, what are our termination obligations if we have individuals who work for us from a temp agency longer than 3 months? So number one, if you have employees through a temporary help agency, speak to your temporary help agency. There are some special rules regarding temporary help agencies. And generally speaking, if someone has worked for longer than 3 months, they're entitled to notice of termination. And a judge might say if an employee has worked for less than 3 months, they're also entitled to notice of termination. So I think it's important, whoever answered that question, speak to an employment lawyer. I'm happy to help, because their age, their type of job is very much going to affect how much notice they are to receive. Can a suspension without pay pending investigation trigger constructive dismissal? No. I think if it's a reasonable investigation that the employer is taking place, and a suspension without pay, I mean, it very much depends on the circumstances. I think if the person has already been suspended with pay, to do a suspension without pay, that might be reasonable. But there might be other situations where it's not reasonable to suspend them without pay. Generally, judges in Ontario say when an employee works, an employee is to be paid. But the whole purpose of a suspension with pay pending investigation is because we don't know the outcome of the investigation. So if the investigation finds that there's no wrongdoing, well, and you didn't pay that employee, an employer might have to pay that employee back. So that's, I think there's probably more to that question. I'm happy to, go into a little more detail offline if you want to speak about that. The next person talks about year-to-year contracts. So this is like a fixed term contract that's renewed every year. Due to pandemic, they have to lay off. Do you have to pay them severance and notice? So the short answer to that question is probably yes, because courts in Ontario recognize that if you have an employee on successive contracts for 1 year, they are not a 1 year employee. They are probably a 2, 3, 4, 5, 6, maybe more year employee. So definitely, speak with an employment lawyer to understand how much notice, termination notice, or possibly severance pay that have to be given to an employee. Kim asks a question. This is another one about signing bonuses. If you provide a contract, or if you want to update the contract, you have to provide more wages. No, there are lots of different signing bonuses that can be given. Anything that would be extra in the contract. It could be a wage increase. It could be a lump sum payment, just a certain amount of money. It could be additional vacation. It could be additional sick days. It could be a different office. It could be a brand new computer. It could be a company car. I mean, it could be an RSP contribution. It really could be anything that isn't already in the contract. It would be an appropriate signing bonus, but definitely speak with a lawyer before you update any contract. Someone asked, do you need documented, I just want to keep track of time here. Do you need documented progressive discipline policies in order to enact that approach? And the court's deem an employee had warning, or can you just walk through the process without a policy? Best practice is to have a policy. If you don't have a written policy, but you're following a reasonable, a method to manage the employee, I would say, you are fine to reasonably treat an employee. And again, this goes back to the obligations we talked about at the beginning. If you're dealing with an employee in good faith, then sure, you are, you're going to deal with them reasonably, with respect, and if their conduct is such that it's deserving of greater and greater discipline, I don't think a court is going to take any problem with that whatsoever. I see some other questions here. I want to get to more questions. So I'm going to look at the shorter ones, but for the longer questions, I'm happy to, to talk about those questions offline. Is it mandatory to pay out unused vacation? So the short answer is yes, okay? And what the Employment Standards Act says is at the time of termination, every employee in Ontario is entitled to any accrued but unused vacation pay. So the short answer is yes, and definitely speak with a lawyer to talk about what what other obligations or what pay might be owing to that employee. Does the employer have to? Christina asked, does an employer have to provide reasonable notice if there's frustration of contract? So that answer is a little more complicated, Christina, but what I will say is yes, there still is certain reasonable, there's certain notice of termination that has to be given to employees if the contract is frustrated. There are some special conditions under the Employment Standards Act for that. So I would definitely say, and it's very specific on the facts. It will only be done on a case-by-case basis. In some cases, yes, there is notice that has to be given, typically when you're dealing with accommodation. And in some cases, no, there is no additional amounts that are owing for frustration of contract. So it very much depends on the circumstance. Miriam asks, what can an employer do if an employee refuses to sign contracts or letters given for constructive dismissal? Oh, sorry, I'm sorry, for progressive discipline. In that case, if you have a conversation with your employee, and maybe there's yourself and the employee and another witness, and that witness is maybe taking notes, and they take diligent notes, and they email them to you saying this is everything that was said in the meeting. If an employee refuses to sign a letter for progressive discipline, it doesn't change the fact that that meeting took place and that warning took place. Whether it be a verbal warning, well, obviously a written warning, or suspensions. An employee does not have to agree with reasonable discipline, but the whole purpose behind that is to get the employee to understand that their conduct is improper and it needs to improve. So if they don't sign, that's okay. Keep very good notes, document everything that is that is said in those meetings, what the employee says and what you say. Now, I just want to recognize it is past 11, so I still have a little bit more time to answer some questions. So I do want to get more, but if someone has other plans or they have another meeting or call to go to, I appreciate your time here and listening to me. And if you have any questions, give me a call, send me an email. Myself and my team would be happy to answer any questions that you have. With regard to notice of termination, can an employer terminate an employee immediately with no notice? So yes, that is possible, only if the employer provides pay in lieu of notice. So it doesn't have to be working notice when an employee is terminated, but there are still minimum amounts of pay in lieu of notice of termination if an employer doesn't want to have that employee continuing to work. Let's see. This is yeah. There are a few really good questions. So, an anonymous attendee asked about, well, wage increases, and every year we give wage increases, but this year due to the pandemic we didn't. And it says, well, what is a reasonable rate? Is that against the Employment Standards Act? And what's the reasonable rate that you have to increase? So the Employment Standards Act is completely silent as to whether you have to increase wages each year. And so what is reasonable, a regional wage increase? Really, it's going to depend on the situation of the employer. Okay, and I think if there's an objective reason that wages can't be increased, that might be valid. At the same time, you might have an employee who said, I've worked here for 10 years, I've got 9 wage increases, I'm starting my 11th year, I want my next wage increase because that's a normal part of my job, is to get the same 2% or 5% wage increase every year. That employee might argue, if you don't give me my wage increase, it's a constructive dismissal. So then I think the question would come down to, is that a significant change or is that an insignificant change? I think anything to do with wages is pretty significant, but is a 2% or a lack of a 2% wage increase or 5%, is that going to trigger a full termination? I think it very much depends on the facts. I think there's really good arguments on both sides, but there's no minimum amount of, under the Employment Standards Act, of wage increase. But a judge might say, listen, you've given 10 wages increases, you have to keep doing it. Or you might get a judge that says you don't. So it's very important to get proper legal advice before you kind of make that change, as in not giving a wage increase. Let's see. Other questions related to termination. So here's one about constructive dismissal. So I'll take a little time from a question from Michelle to talk about the constructive dismissal, and I'll probably use this as my last question. And like I said, if there are any other questions in the chat, I'll ask the organizers here to keep a record of that chat and who sent those questions in, and I'm happy to reach out to you, or you can reach out to me if you have some other questions or would like some more information. So Michelle asks, constructive dismissal. Okay, recalling employees from layoff to duties or positions that are different from their contract. Good question. Due to COVID, the employee's job is no longer available or required. The employee is offered a different position and asked if they would like to come back to work and perform those duties at the same rate of pay. Can that be seen as constructive dismissal? So Michelle, I think that depends on who you ask. If you ask an employer side employment lawyer, they will probably say no. They'll say, no, that's not constructive dismissal because it's reasonable. The job doesn't exist. The Employment Standards Act clearly says that when an employee is brought back to work, they're entitled to the same job or a comparable job. And that's what was done. And of course, the pandemic has affected probably every single employer. I don't think any employer has been left untouched by COVID. And so I think you could come up with a really strong argument to say, that's not a constructive dismissal. It's the same pay. The job duties are different, but it's the same pay, and this is the reality of the workplace. But there might be another lawyer who says that employee is entitled to those specific job duties. And if you don't give the employee those job duties, that is a constructive dismissal. That's the job they wanted. So I think the job duties are really key. If this is like working in a factory and someone works in an office job and their office job is no longer there, but now they have to work on the line, making cookies, for example, well, that might not be reasonable. So it's very much dependent on the specific context of that matter. So, but I think there's arguments on both sides. Probably, well, yeah, I probably would lean on the side of it's not a constructive dismissal, but I would really want to know what those the new job duties are, because that could change things a lot. And I see someone asked, and this is the last question, so a bonus question. A person right before asked a very similar question. If you change the role of employee, that could be viewed as a demotion, but you don't change their pay. And so that's a very similar question to Michelle. If they sign a new contract based around it, does it keep you out of constructive dismissal issues? I would say, the same answer applies. So it really depends on what those job duties are. It depends what the contract says. Was the employee provided with a signing bonus when they signed that contract? Did they have an opportunity to seek legal advice before they signed that contract? I think those are all important points. And there's arguments on both sides. So and the context very much matters. So if you'd like to get in touch with me to talk about that more specifically, I'm happy to do so. So why don't we call it there? We're about 5 or 6 minutes over our hour-long time. But like I said, if there are any other questions or comments that you have, I'm always happy to discuss. And I very much thank you for taking part today.